everyone, welcome back to my channel. Today I'm going to show you how practice Moot code in our college, and my college name is Shillong Law College. So I'll show you how it will practice in our college. I hope you guys are like it. If you still are not subscribe my channel, do subscribe my channel and give thumbs up and watch this video till the end.
5 minutes for reply. Start now.
May please, Your Honor, I am moving the bill application under Section 437 CRPC on behalf of the accused person, namely Shu X and Y. The accused person were implicated in this instant case under Section 302, 376, 2G, 34 IPC. May I draw Your Honor's attention to Section 302 IPC.
302, we understand. You come to 376 direct.
May I draw Your Honor's attention to Section 376 2G IPC, which reads as follows.
The system is good.
Punishment for rape.
Because the researcher is helping the speaker. It should be in this way.
Commits rape shall be punished with rigorous imprisonment of either description for attempt, which shall not less than 10 years, but which may extend to imprisonment for life and shall also be liable to fine. Commits rape during communal or sectarian violence. Your Honor, the brief fact of the case is that the accused person, namely Shu X and Y, were arrested on 3rd 2021 by the Light and Craft Police on allegations that the accused persons Shu X and Y have committed rape and murder against Srimati B at her residence at Light and Craft, Shillong, and the FIR was filed by Sri A at Light and Craft Police Station. Your Honor, may I submit the accused were implicated and arrested simply on the ground of suspicion, and the accused person denies any involvement, and furthermore would like to submit that the statement of Srimati C and D are false and fabricated. That the CCTV camera installed in the premises, the footage of the time of occurrence taken by the investigation officer, does not prevail picture images of the accused person entering the house of the victim. In the such vital evidence, the instant case has been manipulated against the accused person. Furthermore, I would like to submit before this honorable court that the accused person were working as delivery boys of the company Amazon, specialized in delivery items. And the extra copy of the attendant register, which is annexed and submitted before Your Honors, clearly reveal that the accused person were absent from the duty on that day of occurrence. Your Honor, two important points to be noted. First, the CCTV camera does not show any footage of the accused person present on that day of the occurrence at the residence of the victim. And the other point is that the extra copy of the attendance register indicates that the accused person were not present on the duty on the date of occurrence. Hence, it can be presumed that the accused person are innocent and they are not involved in the offences alleged with. That on the date of occurrence, the accused person 3X was undergoing treatment at National Hospital, Shillong, on account of pandemic corona. Your Honor, may I allow to submit the medical report?
Sure.
Your Honor, there is glaring contradiction which will prove that the accused person is innocent. The medical report dated 2/10/21 reveals and confirms that the semen of the accused person matches with the semen found in the vagina of the victim. The medical report does not reveal that belay belongs to which the accused person. Hence, the medical report is contradictory in nature and not reliable. That the accused person made confessional statement under Section 161 CRPC to the police which was done under threat, coercion, under influence, and statement before the police is inadmissible in the eyes of law. May I draw your attention to the Supreme Court, to the section 161 CRPC clause 3. The subsection makes it clear that a police officer is not bound to report any statement, though he may do so if he likes. That the accused person are permanently residing within the jurisdiction of this honorable court, and the accused person are ready to furnish adequate sureties which will stand as a bailer on behalf of the accused person if released and lacks on bail. And most importantly, the case lacks primacy and investigation with connection with this case is incomplete, and the accused person are kept unnecessarily in jail. That the accused person undertakes that they shall not abscond, hamper or temper the prosecution evidence. Rather, they shall cooperate with the investigating agencies. That this is a fit case where your honor can exercise discretion under section 437 CRPC and thereafter be pleased to release the accused person on bail on any terms and conditions as deemed fit and proper.
I would like to add the citation. May I draw your attention? In the case of state of UP versus Papu, the Supreme Court held that the accused had lost virginity earlier. It did not and cannot in law give license to any person to rape her, even if the accused has raped her. She has the right to refuse to submit herself to sexual intercourse to anyone or everyone, because she has the right to object the prey of being assaulted or by anyone and everyone.
The ruling is in your favor or against your favor? Against your favor. Okay, good. Next. You have heard the points? Oh, you have not finished. You have to do the prayer.
No. Just give the citation.
Okay, pray.
Your honor will be graciously be pleased to consider my humble submission and thereafter be pleased to grant the accused person on bail on any terms and conditions as deemed fit and proper.
Good. Reply.
May I say, Your Honor, the council seeks permission to address the benches, Your Honors. Your Honors, I am the PP, public prosecutor representing the state. So, the accused persons, Shri X and Shri Y, have been implicated in this instant case under sections 302/376D, which relates to gang rape. Because of some typographical error, it was mentioned as 376 subsection 2 clause G, that with section 34 of the Indian Penal Code, which is considered to be a very heinous offence, Your Honors. And for this reason, the accused persons should not be considered to be innocent, as the learned defense counsel has expressed that the prosecution witness Srimati C and Srimati D, the statements made by them cannot be relied upon. But one thing I would like to bring to the attention of this court, that the persons employed by Amazon are usually local people.
Yes.
So the Srimati C and Srimati D, being the local residents of that locality, they knew about the accused persons. So when they went into the house, they knew that these persons being of bad character, bad reputation, they suspected something. And when this offence was already committed and it came to light in front of the society, then they came to know that they might be the people, and that is why they gave their statements to the police in that regard. The FIR filed by the deceased victim's husband, Srimati A, is a very genuine piece of document and must be relied upon to initiate the proceedings and investigation against the accused person during the course of investigation. The medical report of the deceased victim submitted on 3rd of October 2021, which says that the semen collected, semen and penile and vaginal swabs from the deceased victim matches with those of the accused persons, Shri X and Shri Y. So, as the Learned Defense Council has pointed that these points cannot be relied upon, that DNA profiling, most of the times it is considered as authentic, and there is hardly any anonymity or any error when we talk about this kind of DNA profiling. Coming to the part where the Learned Defense Council has alleged that the CCTV footage does not contain any image or picture of the accused persons entering the house, I would like to point that at that specific time, the Meghalaya State Electricity Board had cut the electricity. There was load shedding, and in that regard, I can also produce documents to the court to support my case. Also, the Defense Council has pointed that the accused persons were absent from work. But I would like to point to the court that the Amazon authorities are fabricating this claim, and they are trying to somehow save the accused persons from this claim, because as they said that the attendance registrar does not show the presence of their signatures, but their signatures can be easily manipulated, my lord, because it does not have any automated signature machine where the thumb impression can be given. So just signing does not produce any strong evidence that they will not present it on the spot. So the merits of the case can be determined and decided only after conducting evidence in this case, which is pending because of the forensic reports which still awaits disposal. And it is beyond reasonable doubt that the accused persons were involved in this crime, which is very drastic and has severe impact on the society, where we see that women are being the targets, easy targets we can say, of people nowadays.
Offenses.
That your honors, the accused is likely to flee from justice. They are likely to abscond from this place, and this in turn might hamper and tamper with the evidence, and they might hamper and tamper with the evidence, and also this might provide as a hindrance to the smooth investigation of this case. Therefore, I would like to submit that this is a fit case to reject the bail application of the accused persons, as the investigation is still incomplete. It needs some more time, and then we can see that the co-accused are arrested. Confessional statements under section 164 to be recorded by the magistrate is still to be done. So we need some more time, and humbly pray to remand the accused persons to further custody. In this regard, I would also like to cite some judgments. My Lord,
before prayer, you give your judgment before prayer. Citation, okay? Good.
So the Supreme Court in Sunil Fulchand versus Union of India, as having citation AIR 2000 SC 1023, has said that the two paramount considerations for granting bail are likelihood of the accused fleeing from justice and tampering with the evidence. It is essential that due and proper weight should be bestowed on these two factors apart from others. But in this case, we can see that the accused persons are likely to flee from justice, and thus hampering the evidence procedure. So it is my humble request that the bail application
Humble prayer
that the bail application should be rejected for the time being.
Good.
With this foregoing submission, may I rest?
What is the prima facie case? Prima facie case is in favor of acquittal or conviction?
Any you want to reply?
Your Honor, I would like to reply to the statement of the prosecutor that it has said that there was a mistake error in the implementation of section 376B, what I would like to say, Your Honor, how come in this such case of rape, how come the police officer can miss this section instead of G should write it? One point, and the next point is that and also, Your Honor, and this prosecution has stated that the accused, they know that the she was alone at home. So if she was alone at home, if she was raped, because the time of rape also it occurs around 6 to 7. At the time of occurs around 6 to 7, there were a lot of I think the neighbors also are in the locality.
So there is no shouting, there is
There's no
no
shouting.
cry.
If there's a rape, so she have to shout. And also, Your Honor, I would like to reply on this the absence of work. Because the absence of work of the accused, the ex and she wife, they was sent to check up in hospital on that day. So the prosecution state that they was absent from the work because they was absent because they did check up.
Okay, 3 points only. Your 3 points is covered. You want to reply?
As the defense counsel has pointed that the victim did not get any hue and cry. So, as I pointed earlier, that those people are the residents of that locality. So, obviously, when they were entering into the house of the victim, people
They have inquired with the residents.
Yes.
Usually, imagine they used to inquire.
Yes, yes.
Okay, good. Then,
These people, they knew already that there is such a woman whose husband is not at home because they are residents of that same locality. And when they went inside, perhaps they had some weapons in their possession. Maybe they had threatened the victim at night point.
point number 2.
And then when they raised the issue of hospital checkup, Nazareth is not a government hospital, sir. So for claiming that when they were undergoing treatment, the report has to be from a government hospital. And even if they have submitted the prescription medical reports from Nazareth, the bills have not been submitted. So we cannot rely on this evidence for time.
So, after hearing both the parties, I come to the conclusion that confessional statement under section 164 has not been recorded. The bail is kept in abeyance. After recording 164, we can grant the accused person on bail. Okay? You're satisfied? Satisfied? Good. Go. Next.